Hi everyone. So if I am audible to everyone, they can give me a thumbs up or just indicate me that if I am audible and visible to everyone. So welcome guys. And today in this session, what we are going to do, it's a kind of the tedious task to revise the whole constitution in a short span of time. But let's we will be trying to cover up the constitution in a nutshell in a rapid revision kind of the format so that we are able to revise it and get the best out of it just before our examination. So what I have thought here is just that I'll be using the Bare Acts. We'll be revising the stuff through the Bare Act, and if you guys have any questions, we will be taking up that as well, right? So it's a kind of the rapid revision, as you know. So we'll be kind of the spearheading the things in a bit rapid way. We'll be trying to look for the important areas. We'll try to look for those areas which are most probable for our MCQ examination, right? So let's start with that. I'll just share this screen and then we'll start discussing the provisions of the Constitution. Now, what I have observed that throughout this various judicial services examination, there are certain areas which are quite probable for our examination. That in from the Constitution itself, if you see, so there are certain areas which are being cherry picked by the various examiners or the committees which are conducting the commissions which are conducting the examinations. So there are certain areas which are quite probable. Of course, certain questions may be quite trivial in nature. Certain questions you can, having basic knowledge of it, you can also gather information and then you can be able to attempt those questions. So we'll try to cover those areas which are conducive and which are quite low hanging fruit, so that we are maximizing our effort and we are getting best out of that, out of these 2 hours. And we are utilizing these 2 hours in such a way that we are able to solve most of the questions. It cannot be never be like always 100% you are going to get it from any one particular lecture or one particular source. But yeah, of course, what happens is that we will be covering those areas which are the most important ones for our examination for the judicial services. Specifically, you are talking about the MP judicial services, so we'll be looking for that. And what I will try to do, that there are certain questions from the historical background also, which you do not find in the Direct of the Constitution, like when was diarchy introduced, what are all those things. So we'll also try to cover, if possible, during the later phase. But in a nutshell, what we will try is that we will use this Bare Act of our Constitution. This is an official Bare Act. I have downloaded it from the Government of India Legislative Department website, and this is the official one. This is updated till 2022. So there are amendments after 102nd amendment, which will not be included here. But as you know that in this year itself there was certain major amendments to the Constitution, if I have to count one. So that was the amendment with regards to grant of reservations to women in the Legislative Assembly and the Lok Sabha elections, right? Including the Legislative Assembly of Delhi, right? So what happens there is that 106th Amendment Act becomes very, very important for this year's examination, because this is in the backdrop that these are the current events which is happening throughout our constitutional machinery, be it related to certain judgments will be there, which will be taken up by the Supreme Courts. Year of 2023 has been the year, like most important judgments on the various issues has been uh, rolled out by the Supreme Court, right? And even in the legislative front, there has been certain enactments, be it with regard to the Delhi Services Enactment, or be it the constitutional amendment of 106th Amendment. So these are certain key areas you should be keeping an eye on, apart from the basic and static study of the Bare Act, because there are certain, of course, there are those anything you read in the Constitution, anything which is happening in the recent time with related to constitution has got some linkage, backward linkage with the constitution itself. So even if you think that there are matter in the current affairs, this is the actually the matter in the static portion as well, right? So in a way, if we target these areas, we'll be able to target certain areas, certain questions in a quite easy manner. If we have the basics understanding of it, there will be certain questions will be like, hey, where we need not to worry about that. If you are aware about that fact, it's very good. If you're not aware about the fact, let's try to you can not go for that. There are certain questions also like that, right? So what our goal here is to try and capture those questions which can be easily uh, answered by going through a sort of revision here, right? So let's start with it. We will start with the articles of the Constitution. We'll start with Article 1. We'll try to finish this thing in a kind of the very rapid way, and we'll be looking for the most important provisions of the constitutions, right? And part wise, we'll be looking for it. So let's start firstly with the preamble. There are certain questions which are coming out of preamble. Of course, you will find across the service commission, across the judicial services examination, be it for MP, be it for UP, various commissions has asked this question, one or two questions specifically on the preamble. Now this is one of the area which will be kind of the very productive area considering the amount of study you have to put in. Hardly it's 80 81 word thing, the preamble. And if it is giving you one question, and simply by having a minute or two spending here, if you are able to get one or two right questions in your examination, so what harm in there, right? So there are two three kinds of the question you can expect from the preamble. They would be asking the meanings of these key terms. The key terms is like sovereign, socialist, secular, democratic, republic. The second, they might be asking about the amendments in the preamble, right? And the fourth third thing, they will be asking about if there is any judgments with regard to the preamble, for example Berubari Union, Keshwananda Bharti, that with regard to that whether the preamble is the part of constitution or not, right? So preamble is a kind of the preface to the Constitution of India, you can say. It's kind of the synopsis which gives in a nutshell about whatever the things are there. We can simply, after reading this preamble, we can gather quite bit of idea about the principles, the morality which is being talked about in the constitution. So it gives us certain idea. Firstly, like you can see, it starts with the word we the people of India. It says we the people of India, right? Here you can say, right, it says we the people of India. So this is indicating towards a fact that the source of very source of authority is being derived from the people of India itself, right? So preamble is itself declaring that the Constitution of India, whenever it was made, I'll just give you a background of that. Also, there are two three questions which I have seen in the judicial services. So they would be asking question about that, under which scheme, what was the scheme, and under which plan the Constitution of India was made. So it was that when it was evident that India will get independence and the power will be transferred from British to Indians, then British government sent a cabinet mission in India. British government sent a cabinet mission in India, and in that mission there were three members. There were three members in the cabinet mission, and that cabinet mission laid out a plan to constitute the Constituent Assembly of India, and that Constituent Assembly was given this task to formulate the Constitution of India by the Indians. So now that their country will gain independence, so how and by what means the this country will be governed? We required a constitution. See, the basic purpose of the constitution itself is to put a limitation on the arbitrary exercise of the powers by the government. If there is no powers, the state will become, or if there is no authority which is limiting the powers of the state or the government, the state in its all probability will grow more and more powerful, and there will be a threat to the fundamental rights of the people. So there need to be a balance between the collective good, balance between the welfare, and there need to be a balance between that what state can do and what state cannot do. There are multiple functions which is being performed by the constitution, but biggest of it is to limit the government by a scheme and structure by this is what we call is constitutionalism, the idea of constitutionalism, right? So this whole idea of making the constitution started from of course making the constitution of India by Indian. It started around 1930s, and as soon as we approached our independence, so the things got clear. The cabinet mission came into India in 1946, and under that cabinet mission plan, the constitution of India was formulated by the constituent assembly. So that constituent assembly led to this enactment of the preamble itself, and it gives us a very basic idea. Firstly, what is the source of the authority of the constitution? It is the people. Now it gives another idea that what is the nature of the Indian state, like sovereign, socialist, secular, democratic, republic. These are the natures of the Indian state. It is saying, you see, we the people of India having solemnly resolved to constitute India into, the people of India wants India to be into form of sovereign, socialist, secular, democratic republic. So this is what is the nature of Indian state. And it also sets certain goals to be achieved. Goals like justice, liberty, equality, fraternity. Justice has various kinds. So what here from your examination point of view, you should note that sometimes they will ask about what kind of justice is being talked about. So justice is social, economical, political. They might include religious, or they might include certain anything else in this, and they can ask in the MCQ that which of these kinds of justice is being talked about in the preamble, right? So here it is talking about the three kinds of justice: economic, social, and political. Liberty, again, belief, thought, expression, and worship. Equality of status and of opportunity. And then it also talks about fraternity, and that fraternity assuring the dignity of the individual and unity and integrity of the nation. So, firstly, this is the source of authority. This is the nature of Indian state, right? These are certain objectives which our constitution needs to fulfill. These are certain basic information you will get after reading the preamble, and this is quite useful for your examination. You can get an idea and you can try to solve certain question based upon this minor thing, right? There then comes one another important thing, that is there anything which has been inserted into the preamble by an amendment? So once the preamble of India, constitution of India, was enacted, it also gives an idea that when it was enacted. So it was enacted on the 26th day of November 1949. So 26th of November 1949 is the date when we completed the work of enacting our constitution. And on that particular day, we had adopted, enacted, and given to ourselves this constitution. So once it was in 26th of November 1949, the preamble did not contain three words, that is socialist. One here is socialist, another is secular, and unity and integrity of the nation. These were the three words which were later inserted, and these were inserted by 42nd Amendment Act in the year 1976. So there is another important thing you should note about the chapter of preamble here, and I think that this will be all what you'll require to answer a few questions from this topic, right? So this is about preamble. Now let's start studying part by part, and we'll try to touch the important provisions of every part, and we'll see what could be the probable area once they will be asking the question. Now there are a few parts they will be focusing in your examination quite more, especially the parts of parliament, the judiciary, and the executive, union executive, state executive, about the roles and responsibility of the president, governor, the powers of the president, governor. Those are the key areas. Then another key area is your center state relationship. You might be focusing on that particular thing as well, so that you are getting good amount of questions solved in your examination. These are the important areas. From fundamental rights, basically they might be asking in MCQ the factual things, specifically with regards to the certain distinction between whether these rights are available to the citizens, what right are available not to the citizens or to anyone else as well along with the citizens, right? Then might be asking about classification. They might be also asking a difference between constitution and the fundamental right. What are the sets of right which are constitutional, not a fundamental right? So on these criteria they will be asking. And in the segment of the fundamental rights, there are two three smaller fundamental rights which we often tend to neglect, like right against exploitation, cultural and educational right, constitutional remedies, right to equality, freedom. Everyone have read in very detail. For mains purpose, for pre purpose, we have read in very detail. but there are certain trivial areas which we tend to neglect. So in this particular lecture, what we are going to look specifically for those trivial areas you might have missed it, right? Okay, so let's begin our discussion on the part by part study of our constitution. So, as you know, there are at present now 25 parts in our constitution, and they all talks about different thing. Part one in the sequence talks about India's union and its territory. It spans from article 1 and it goes on to article 4. So article 1 to 4 of the constitution talks about India's union and its territory. You see, there is a very basic definition of the word state in the political science. So if you read if you have to define anything as a state, you need to prove the four essential element of the state, right? So if you have to see that anything is a state, you need to say that it has firstly the people around it, right? The population, then territory, the area, then the government, and then the sovereignty. These are the four basic criteria what any entity should have before it is declared as a state. Now, if you observe minutely, you will find that these things are elaborated in our constitution. If you have to talk about the India's territory, you see the second element where it is being talked about in constitution, article 1 to 4. If you have to talk about India's population, where it is talked about, article 5 to 11 of the constitution, that is the citizenship. Now if we have to talk about the government, where it is talked about, you see part 5, part 6, it's talking about the union, the state. In within that particular part, it is talking about union executive, state executive, union legislature, state legislature, the judicial system of India. So this is what the system of government it is being talked about, right? And then sovereignty, article 1 itself makes India a sovereign country. India is a quite this thing capable of acquiring any territory, ceding any territory. India is not bound to follow any external opinion while it's dealing with its foreign affairs. Sovereignty means any country or any state which is independent internally as well as externally. We have seen in the preamble as well that India is a sovereign country, right? So all of these elements of what is required to be a state are being dealt specifically in our constitution, right? So you see, if you have to start looking at part one, you see article one. It is talking about, now this is a very debatable thing. Very recently there was a debate during the G20 that president of India was replaced by the president of Bharat. So this constitution of India, there are, it's not like that it's only the constitution of India which is using the two names for its country. There are various countries. For example, you see Ireland is also using that Ire and Ireland. These are the two names which is used for the in the constitution of Ireland. Similarly, for the constitution of India, we are using the two names. One is India, that is the English name, the foreign name, and another is the Bharat, that is the traditional name. Why these two names? Because there was lack of consensus on using either of the names, that is India or Bharat. However, there were certain suggestions in the Constituent Assembly to use certain other names like Hindustan, etc. Right? But finally, it settled down that India, that is Bharat, shall be a union of state. Right? Now, the bigger question is whether it is India, whether it is Bharat. That is not a bigger question. Any which way you refer, that will be we will be referring to us only. But here you get an important information is that union of the state. So, what does union of state means? Now, there are two kinds of systems. One is a federation, another is the unitary system of government. So, what there are two important system of the government. One is federal system, and another is unitary system. One is federal system and another is unitary system. So it's basically about the division of powers, how powers are divided. If there are different levels of the government, if there are different tiers of the government, so if the powers are divided, that okay, union will do certain legislative work, union will have the executive power, they will be extended till here, and then the judiciary of union will be doing these many works. So this is what federation. If there is a division of power between different tiers of the government, that is called a federal form of government. However, if there is concentration of power, all the powers are concentrated at only and only one place, that is known as the unitary form of government. That is known as unitary form of government, right? So what India is essentially, it is a federal form of government, because we will see during the center state relationship chapter that the whole power is divided into union, states. We have schedule 7 that gives divides the legislative power. We have the distribution of administrative relationship between union and state, and then we also have financial relationship which is divided between union and state. So essentially we are a federation. But if you talk about the theoretical federation, wherein states come together and they form an agreement and they form a federation, so India was not conceived into that federation. Rather, though there is a division of power, but that division of power is tilted more towards the center. So this is why there are certain scholars who have termed the Constitution of India, of course, it is a federal country, but that is kind of the bias towards union. So people call it a quasi federation or a federation with unitary bias, whatever they like. Of course, they have their explanations for that, right? So if you refer the word union of state here under Article 1, it is essentially indicating towards the federal structure. In the union of state, only those are included which are the states, not which are union territories. So there are two different words. You see, agar ek hi hota, so had it been that part one would relate only to the India's union, why they require to write another term that is territory? Because both are different in nature. Union include only those which are the part of the states, which are the designated states. For example, MP, UP, Maharashtra, Rajasthan, these are the states. But if I talk about the territory, so territory includes all the state plus all those other territories as well, which are not the states, right? And you see that distinction being given here, right? So what says the territory of India shall comprise of all the states and the union territories which are specified in the first schedule. So first schedule to the Constitution of India contains the list of all the states, and it also contains the list of all the union territories, right? So if I refer that territory of India, that includes states as well as union territory. If I refer only union of states, that means only and only those which are designated as states, right? So territory of India includes these three things. One is territory of all the state, the union territory, and such other territories which are later acquired by the Union of India, right? Then moving on to Article 2, it talks about, it gives the power to the parliament to admit into union. Now, union of states, suppose that today we have 28 states. So this is what is corresponding to union of a state. This is corresponding to union of a state. If I say India is a union of states, so that at present includes 28 states. So tomorrow, if any new states has to be included, for example, Goa was not earlier a state, it was later given the statehood. So now it is the part of this union of state, but earlier it was not the part of the union of states, right? So if any territory has to be included under this term union of the states, then who has the power to do that? That is the parliament has the sole power to do that. State legislature have no say here, right? So this is Article 2, that power to admit a new state into the union, establish a new state, and then admit that state into the union of state is lying with the parliament. Now, parliament enjoys very another power, and that is a unilateral power again, to make certain alterations in the state. If the names of the state has to be changed, if area of any state has to be increased, area of any state has to be decreased, boundaries has to be changed, nomenclature has to be changed, one state is to be divided into two states are to be merged into one, right? So all of these can be done by the parliament by passing a law. So whenever you find this parliament may by law, so law means it is being passed by a simple majority. Law of the parliament is getting passed by simple majority, right? So here is a very tricky thing, that even though certain aspects of the constitution are getting changed here, but that is being done only by the simple majority, only by the simple majority. So it is specifically writing that parliament may by law, it can form a new state by separation of the territory, or uniting the two states and form another new state, increase the area, decrease the area, alter the boundaries, alter the name, right? So they can simply present a bill, but that bill should be presented in either house of the parliament only on the prior recommendation of the president, right? So this is the criteria. Firstly, what happens, that if a name has to be changed or anything has to be done, has to be increased, so a bill will be presented in the parliament with the prior recommendation of the president of India. Parliament will pass that particular thing. In the meanwhile, the president of India will send for the recommendation of the respective concerned state, that what is your opinion, we are going to divide your state into two, or we are going to unite your state and form a new state, right? So they will seek the information, opinion of the states, but that opinion of the state is not binding upon the parliament. Parliament can keep aside the opinion which is given by the state and can still continue with the process of alteration of the state, right? But if you see that I have already talked about that, you see here it is mentioning what the union territory is specified in the first schedule. Also, you should be noting that names of all the states in India are mentioned in the first schedule. So if tomorrow one state is split into two, for example, Andhra Pradesh was split into Andhra and Telangana. So earlier there was one state Andhra. Now there has to be another inclusion, that is Telangana. So it will make necessary changes into schedule 1. Apart from that, there is a schedule 4 as well. That schedule 4 contains the list of the seats which is allocated to the different states in the Rajya Sabha. So even if the names of one state is getting changed, even if the one state is bifurcated into two or two states are joined, it will have necessary incidental and consequential changes in the first and the fourth schedule. So if anything is getting changed in the constitution, that amounts to amendment. But as we all know, amendment under 368 requires a special majority. But now this act, as already we have discussed, it is getting passed by the simple majority. Then how come it is possible? Because this has been explicitly exempted that anything which is being done under Article 2 and 3, this will have necessary changes in Schedule 1st and 4th, but this will not be deemed an amendment for the purpose of Article 368. So that it can be done even without the special majority, right? So this is a nutshell of part 1 of the Constitution. Let's move on to part 2, and that amounts to the citizenship. Now, part 2 of the Constitution deals about the citizenship of those people who were at the time present during the commencement of the Constitution. इंडिया में रह रहे थे, इंडिया से रिलेटेड थे. Now you know that once India got independence, partition also happened. So people migrated from India to Pakistan and Pakistan to India. So it basically, part 2 basically uh, talks about the citizenship of the people who were then present in the India, right? But it does not talks about the people who have taken birth after 1950. For that, under Article 11, power has been given to the Parliament, and Parliament, using that power, has enacted the Citizenship Act of 1955. And by that, under that act, there are 5 ways of acquiring the citizenship and 3 ways through which the citizenship of a person can be terminated or can be deprived of, right? So let's understand this thing. Article 5 gives us the citizenship by domicile. So it talks about those person at the commencement of the Constitution, every person who has the domicile in India. First criteria is they should have a domicile. So Article 5 will give this thing that there is 2 criteria needs to be fulfilled. That first, the person was domiciled in India, and the second criteria is either they fulfill one out of these things. Firstly, what happens is the person is domiciled in India and who was born in India. This is that makes him a citizen of India, or he is domiciled in India. Either of his parents were born in the territory of India, right? Or even if it is not there, so person is domiciled in India, and for the past 5 years he has been immediately before making commencement of the Constitution. Past 5 years he has been ordinarily residing in India. So they were all given the citizenship. So this is called citizenship by domicile, and this is given by the virtue of Article 5 of the Constitution. Now, Article 6 gives the citizenship rights to those persons who migrated from Pakistan. Now, East Pakistan, West Pakistan, both territories included. So they migrated to the India from those territories, right? So if they migrated from Pakistan before the 19th July of 19th day of July 1948, that is 19th July 1948, If they migrated to India, they were given the citizenship under this Article 6, right? What about they migrated after that? So should they not be allowed the citizenship? They will be given, but not under the term of migration. They will not be given the citizenship under migration, provided they will have to register themselves. So they will be requiring a certificate of registration, and if government is satisfied, then government can grant them the citizenship, right? So what happens? It is talking about those persons who migrated from Pakistan and lived up in India. Article 6 applies to them. Now, Article 7 is a kind of the tricky situation. It says that suppose that India got independence, both of the country got independence. Now, some of the people migrated to Pakistan, but they didn't find the situation conducive there, and they later returned back to the territory of India. So, what about those persons? The moment they migrate from India to Pakistan, they lose their rights of citizenship under Article 5, that is domicile, because they have migrated from India to Pakistan. Now, now they are willing to return to India, or they have returned on a permanent basis. So under which article they will be treated, right? So for that, they have Article 7. These are granting, Article 7 is granting the citizenship to certain persons who migrated to Pakistan but later returned back to India, right? Prima facie, they will not be treated as a citizen, but they will require that they will have to apply for the registration, and if government is registering them as a citizen, they will be given the citizenship status, right? Okay. Now we have Article 8. Article 8 gives the citizenship for persons of Indian origin. Now this will apply to those persons who belonged to India. Their parents or grandparents were born in India. The particular person was not born in India. Person was born in India, or either of their parents were born in India, or their grandparents were born in India. But now they are living abroad, and now after India is getting independence, they want to become the citizen, so they will be deemed persons of Indian origin. They will be deemed as persons of Indian origin, and Article 8 is there to grant the citizenship. Article 9 is a very important provision. This promotes the concept of single citizenship. This promotes the concept of single citizenship in India. So it says any person who voluntarily acquires the citizenship of a foreign state will not be the citizen of India, right? And this concept you will find applied under the Citizenship Act of 1955 itself. So India follow what? Concept of single domicile and concept of single citizenship as well. Concept of single domicile as well as single citizenship, both are there. Single domicile we have seen under Article 5, single citizenship under Article 9, right? So these are the important provision with regards to the citizenship, which are dealt under Part 2 of the Constitution. Article 5 goes on to Article 11. Article 11 gives the power to the Parliament to make the law, or to regulate the rights regarding the citizenship. With this regard, Parliament has made a law, Citizenship Act of 1955. There has been certain amendments into that time and again, and that particular act is giving us the citizenship after the commencement of the Constitution, right? So this is the Part 2 of the Constitution. Let's move on to Part 3 of the Constitution. We'll go sequentially till fundamental duties, because those are the theoretical part. Those are the important part. We have to do it article by article. Thereafter, we'll be looking in a nutshell over the, for legislature, executive, and judiciary. We'll have this discussion, right? So, part 3, Article 12 to 35 deals with the fundamental rights, right? Fundamental rights are essentially the claims of the citizens against the arbitrary actions of the state. These are the protections given. These protections are very essential, very fundamental for the overall development of any person, any citizen, right? This is why they have been given the highest order of the protection. There are three categories of the rights. There are other categories of the right as well. I'll simply try to explain the difference between them. So one you can say is fundamental right. One is fundamental right, it is mentioned here. Another is legal right. Another is constitutional right. And then you can have natural right. You can also have human right. You can also have human right. So there are different categories of the right. Now, what is the major difference is the protection given to these rights. If you have to see which of these rights are most protected, protection meaning that in case of their violation you get the immediate and effective remedy. You might have heard about the statement given by Dr. Ambedkar that Article 32 is the heart and soul of the Indian Constitution. And what is Article 32? It is prescribing for right to constitutional remedies. That says if in the case of violation of any of the fundamental rights, persons, those whose fundamental rights are getting violated, are empowered to directly seek to the Supreme Court, and Supreme Court is also empowered to restore their fundamental rights, and for this purpose they can even order certain writs, and there are five kinds of writs. So in case of violation of fundamental right, person can directly go to the Supreme Court. Now, legal right, now fundamental rights, of course, you should know that it is the part and parcel of the Constitution of India. Anything which needs to be amended, firstly, needs a special majority. So it's very tough to amend the portions of the fundamental rights. And also, most of the principles of the fundamental rights are the part of the basic structure like liberty, equality, judicial review. These are the part of the basic structure. So they cannot be even amended by the parliament, right? So what happens here is that fundamental rights are most protected. Then what about the legal rights? Legal right kya hota hai? So legal right are those rights which are guaranteed to any citizens or even for any person by the virtue of any law which is made by the legislature. If any law is enacted and that law is giving anyone a legal right, so that will be called a legal right. For example, right to information. So in 2005, Right to Information Act was enacted, and that particular act gives every citizen of India a right to demand information from public authorities. So what happens there is that is a right that is given by an act, that is given by a law. Now, tomorrow, if Parliament repeals that act, that will require simple majority. That is quite easy thing to do. Anyone who is having the government, they command the majority in the Lok Sabha, so they have the simple majority in the Lok Sabha always. It's quite possible that they are commanding 2 3 states, so they might also have the majority in the Rajya Sabha as well. That is a national party. If they are, so they obviously might be in the majority in the simple majority in the Rajya Sabha as well. So it's quite possible for them to amend those right and take away those rights. So if you compare legal rights and fundamental rights are most protected. But apart from fundamental rights, there are certain rights which are there in the Constitution, but they are not kept under the chapter of fundamental right. For example, universal adult suffrage under Article 326. This is a constitutional right, though this is not in the this thing chapter of fundamental right, but still it is a right which is given to everyone who is above 18 years of age to get themselves enrolled in the voter list. Every citizen of India, so that is a right which is given. So this is what a kind of the constitutional right. So basic difference in the nature of the protection which is being given to these rights. Okay, so we have fundamental rights spanning from Article 12 to 35. Article 12 simply defines state, because we have just now seen that rights are claims against the state. So it is pertinent to know who are the state and against whom the citizens can claim the right. So it says the government and the Parliament of India, government and the legislature of the states, local authority which are within the territory of India, or any authority under the control of those authorities, they will be deemed as the state, right? So here, if this discussion might prolong if you dig deeper into the what amounts to state, what not amounts to state, right? But basically, what you need to apply is the essential function test. So if anything is which is a parliament, if anything is the government of the state or the union or the local authority, they simply by default becomes the part of the state. Any authority under their control, right? And their essential function is to discharge the duties of the state, they will be termed as state. This is the simple principle you need to keep into account. Now, why we are defining the state? Because there are certain obligations which have been put upon the state under various article of various subsequent article, you see, because Article 13 says state cannot do that, state cannot do this, right? Article 13 says that state shall not make any laws, state shall not make any law if a state is making any law which is violating the fundamental right, which is in contravention to this chapter, this part shall be deemed void to the extent of that contravention. So Article 13 subclause 2 puts a clear ban on the state, instrumentality of the state, to enact any laws which are violating the fundamental right. The state cannot do anything after the constitution has commenced. So if there is any law which is made by the state and that is violating the fundamental right, they are liable to be declared unconstitutional. Now, in what amount? To the extent of that contravention. Herein you include a doctrine of severability. You have to sever the consistent provision with from the non-consistent provision, and those provisions of the law which is inconsistent with the fundamental right, they will be declared void. Now, Article 13(1) is talking about the pre-constitutional laws. That if any law which is there in the force in the territory of India immediately before the commencement of this constitution, even if they are violating any provisions of the fundamental right, to such extency, to such inconsistency, they will also be deemed as void. Right? So these are the two important obligation of the state which has been put under Article 13. Right? But this is a bigger confusion that law which is being the state has been given this ordained by the constitution not to enact any law. So what is being actually included in the law? Is it simply meaning that anything which is made by the parliament? Is it also including anything which is promulgated by the president in the manner of ordinance or order or vice laws? So it's been settled in the Article 13 subclause 3 itself. It says law will include ordinance, order, bylaw, rules, regulation, all those things which is having the force of the law in the territory of India. So anything like that sort, that will be deemed as a law, and any law which is violating the fundamental rights shall be deemed unconstitutional. Right? So this is Article 12 and 13. Thereafter, we will find that we have 6 categories of fundamental rights. One is right to equality. It spans from Article 14, goes on to Article 18. Article 14 talks about equality before law. So equality before law, it says state shall not deny to any person equality before law and equal protection of law. These are the two concepts which might look similar, but they are never the same. Equality before law means that everyone is equal before law. Law is above all. There has to be the rule of law. There shall be no arbitrary powers in the hands of any individual. While equal protection of law promotes that equality, of course, there should be equality, but this equality should be among equal person. So it talks about equality of equals. Equal protection of law talks about equality of equals. Equality before law is a kind of the blanket equality which says there shall be no arbitrary powers. Everyone is equal. No one shall be given the preferential treatment. But the equal protection of law concept says that those who are placed equally and similarly in the society, they are actually equal and they should be given the equal protection in equal amount. So both of these concepts are included under Article 14. Article 14 is the kind of the you can say genus. Even if there is, you see, there are two bigger articles, 15 and 16, which provides there should be equality because there will be no discrimination. 16 says there will be equality in the opportunity of the public employment. So both are specific in nature. One says there shall be no discrimination, other says there should be equality of opportunity. But these two only does not suffice the whole concept of equality. So even when where Article 15 and 16 fall short, Article 14 will come to the rescue. So it's a bigger concept. It's an umbrella concept, right? It says equality of before law and equal protection of the law, right? Then what we need to focus in Article 15 is this grounds then upon which the discrimination cannot happen, right? So Article 15 says, acha, this thing you should note here that Article 15 is only available to the citizens. Article 15 is only available to the citizens, while there is no such restriction. It is saying that any person, 14 is saying any person, 15 is saying citizens. So you have to distinguish that Article 15, this Article 15, Article 15, Article 16, Article 19, Article 29 and 30. These are the 5 fundamental rights which are only available to the citizens. Rest other fundamental rights are available both to the citizens as well as non-citizens. Right. So it says Article 15 says The state shall not discriminate against any citizens only on the grounds of race, religion, caste, sex, place of birth, or any of them. So this is a providing for it is seeking to create an environment which is providing that there is equality of status, that everyone is enjoying equal social status. And the makers of the constitution were quite aware that on these grounds, on the grounds of race, religion, caste, sex, place of birth, there has been certain disabilities or liabilities or restrictions which traditionally have been given to particular section of the society. So they mentions that these kinds of discriminations cannot be done against any person, right? But this is a general rule which is saying that article 15 is saying that there shall be no discrimination. However, article 15 itself provides the exception to this rule, exception to this general rule, that okay, we will not discriminate against any citizens on the grounds of race, religion, caste, or sex, or place of birth. But what about those persons who have been traditionally discriminated? So we need to protect them. And in order to protect them, state will require certain affirmative action. State can do something more for those disadvantaged section of the society. And who are those? They are mentioned from article 15, 3, 4, 5, like that. So in a nutshell, article 15 is talking about that there shall be no discrimination, but rather article 15 later on provides that there has to be certain protective discrimination so that actually there is equality in the society, right? So what happens here is article 15.3 says state is empowered to make special provision for the women and children. Thereafter, state is also empowered to make special provisions for the socially and educationally backward classes of the citizens, scheduled castes and scheduled tribes. And that provision may also include for providing for reservations in educational institution, providing for reservation in educational institution, right? Later on, there has been another provision which is being added, and that was added by Constitutional 103rd Amendment Act, and that was grant of reservation to EWS, economically weaker section of the society. You see, it is being mentioned here that in educational institution, a maximum of 10% seats shall be reserved in each category for members of economically weaker section of the society. So Article 15 talks about the provisions for special protection which is given to women, socially and educationally backward class of the citizens, scheduled castes, scheduled tribes, and now with the 103rd Amendment, a maximum of 10% reservation in educational institution can be given to the members of economically weaker section of the society. Right. Now, this article from the MCQ point of view, we are simply touching in detail. These are very, very elaborate articles, right? So we are simply going through it. We are simply scanning, browsing through it because in detail it requires a great deal of discussion that we will do during the time of mains examination, right? So what happens is the next article. Next article is providing equality of opportunity whenever there is a case of public employment. So Article 16 again says all the citizens, there shall be equality of opportunity for all citizens in the matters relating to employment or appointment to any offices under the state, right? So this is an, if there is appointment, public appointment to any office which is under the substantial control of the state, every citizen shall be given equal treatment, and there shall be no discrimination. Here you will find two extra grounds will be added. One will be descent and place of residence. So no citizen shall be discriminated only on the grounds of religion, race, caste, sex, descent, place of birth, or any of them. On that ground, they shall not be declared ineligible or discriminated in respect of any employment under the office of the state, right? However, there are certain exceptions again which is created under Article 16 subclause 3. Now this is the exceptions to the general rule of equality which is again propounded under Article 16 1 and 2. So it says Parliament will have a certain power to reserve a certain class or of appointment or offices which requires requirement as to residence in the particular territory before applying or appointment to that particular post, right? So this is an exception which is created to the general rule. Apart from that, there is Article 16.4. It gives the power that state can make certain provisions if it finds that certain backward class of the citizens which is not adequately represented in the service under the state. So if there is any backward class of the citizen and state is of the opinion that they are not edu, for example, there are 100 posts in any service, and out of that, that particular group does not even constitute 2 or 3%, however, their population is 40%. So this is indicating towards a fact of underrepresentation. So if in the opinion of the state there is an underrepresentation, so state is empowered to make the reservation of the appointment in the favor of those backward class of the citizens which are not adequately represented in a particular service, right? And in this category there are various reservations which has been provided, which are to the scheduled caste, to the scheduled tribes, and then to the OBCs, which you can call socially and educationally backward classes. And now the members of EWS, they have also got a maximum of 10% reservation in jobs, right? Now there is another amendment which has been carried out that prescribes for the reservation in promotions. Now reservation in jobs has been given to the OBC, EWS, scheduled caste, scheduled tribes, but reservation in promotion you will find only for the scheduled caste and scheduled tribes, right? However, if you have to see this Article 16, you need to look that Article 16 with the, you need to read it with Article 335 of the Constitution. Article 335 of the Constitution, I'll just show, let's see, Article 335 of the Constitution, what does it says? That claims of the members of scheduled castes and scheduled tribes shall be taken into consideration with the maintenance of efficiency in the administration. So it's not that if we are reserving any post, so we should be reserving like irrational number or unreasonable number. So for this, a balance has to be created, that of course social affirmative action is also made out, the social upliftment of certain section is also done, and provided with that there is no compromise in the efficiency of the administration. So with this, what happens, that you will find that in the Indira Swani case, Supreme Court has put a cap of 50% on the reservation. Now, in ordinary situation, Supreme Court is of the opinion that reservation cap cannot be more than 50%. Now, this, while there was a case on the EWS this year itself, wherein Supreme Court has given this constitutional validity to additional 10% reservations, which is now taking the total tally to 59.5%, that is almost around 60%. So Supreme Court had declared it constitutional, and it says it is not violating the Indira Sawani guidelines. Why? Because the Indira Sawani guidelines is only for the caste-based reservation to the scheduled caste, scheduled tribes, or the socially and educationally backward classes, right? So we need to understand that, okay, what is the purpose of the reservation? To provide the social upliftment. So you provide for the to tackle the underrepresentation in the services, to provide for a great representation of all the community in the services. And if there is representation given to that to section in the society in the services, that should also not compromise with the overall efficiency. So Article 16 and 335 goes hand in hand, and this is where Supreme Court has strike down a balance by keeping a cap of 50%, right? So this is about Article 16. This is about Article 16, right? Now, moving on, there are certain smaller articles in the fundamental rights itself. Article 17, which talks about untouchability. Untouchability in any form is forbidden. And if anyone is practicing untouchability, imposing any disability out of untouchability, that is an offense punishable in accordance with the law. And for this, Parliament has enacted Civil Rights Protection Act, Civil Rights Protection Act, Civil Rights Protection Act, Civil Rights Protection Act. So that punishes any disability which is caused to any person because of the untouchability. Civil right has been defined there as any right which has arisen accrued in anyone due to abolition of untouchability. It is one of the absolute right. In all sense, it says untouchability in any form is forbidden. There is no qualification. You will find that there are various articles of the constitution, specifically fundamental right, they are providing us certain rights, but they are coming with certain restrictions. But article 17 के ऊपर ऐसा कोई restrictions नहीं लगा है. You will see untouchability in any form is forbidden, and anyone doing in untouchability shall be punished according to the law. And for that we have Civil Rights Protection Act. Okay. Then another sort of right to equality is abolition of titles. Why we say that abolition of titles is very necessary for equality? Because titles, specifically those titles which are given by birth and which gets transferred from general, for example, lords. Someone is a lord, then their children will be super lord, their children will be another lord. So this tend to, specifically you see the kind of the jamindari system, someone will consider themselves raja dhiraj. These kinds of titles were quite prevalent. So this creates what? A class which is privileged and the class which is non-privileged, and there will be gap in the society. So in order that these gaps are fulfilled and there is no such division in the society, there is no social discrimination, these kinds of privileges, these kinds of titles needed to be abolished. So it says any title which is not being a military title or academic distinction shall not be conferred by the state. State government shall not confer to anyone any titles except the military or academic title. Academic title, for example, PhD, someone is a doctorate, someone is a D.Lit, whatever, the academic title, these are earned by merit. These titles, academic distinctions are earned by merit. Military awards are for bravery, gallantry, right? So there are certain merits involved there. There is nothing to do with the birth, right? So Article 18 says state shall not give anyone any title except military or academic. No citizen of India shall accept any title from the foreign state. And third says no person who is even not a citizen of India but is holding any office of profit with the government of India, they shall even not accept any titles from a foreign state without the consent of the president. So firstly, government will not give any title. The citizen of India will not accept any title from foreign state. Thirdly, the persons who are employed under the government of India, specifically the office of profit, and they even are not the citizen of India, they are not supposed to accept any titles from foreign state without the consent of the president, right? So this is abolition of titles under Article 18. Now after right to equality, we have right to freedom, that is giving us 6 kinds of freedom. In this article specifically, you need to remember what are the reasonable restrictions which has been put. So for your ease of understanding, you can make a table like this. On one side you can write your fundamental right, Article 19(1)(a), and then other side you can put the reasonable restriction. This will help you in kind of the quick revision. So Article 19 gives us 6 kinds of fundamental rights, and each of these fundamental rights are reasonably restricted. So if you talk about freedom of speech and expression, this is the first kind of fundamental right which is given under Article 19, and the reasonable restrictions put upon it are given under Article 19 too. These are sovereignty and integrity of the state, India, security of the state, friendly relation of India with the foreign state, public order, decency or morality, contempt of court, defamation, and incitement to an offense. So you should make a table like this later on while you have time, or for your future reference as well, that okay, on one side you are writing this fundamental right, another side you are writing the reasonable restrictions which has been put upon. If you want, you can mention the article for both the reasonable restrictions and the this thing fundamental right. So freedom of speech and expression, it's quite an important fundamental right, one of the most important fundamental right. This is why we are able to speak freely, we are able to express freely. And this is again one of the expanded fundamental right, not as much as Article 21, but it is of course indeed, it includes freedom of press, it includes right to remain silent, it includes various other right to be informed about, right? So this is one of the most important fundamental right, but ironically you will see that it is one of the most restricted fundamental rights as well. Under Article 19, there are no other fundamental right which has got such a heavy restriction as compared to Article 19(1)(a), that is freedom of speech and expression, right? So what kind of reasonable restriction is there? You need to remember it: sovereignty, integrity of India, security of the state, friendly relation of India with foreign states, public order, decency or morality, contempt of court, defamation, or incitement to an offense. So these are the reasonable restrictions which has been put upon our fundamental right of freedom of speech and expression. Now, what we have is the right to assemble peacefully without arms. So you also have the right to assembly, but there is again qualification which has been put in the form of reasonable restrictions, and those reasonable restrictions are given under Article 19.3, and they are sovereignty and integrity of India, public order, and these are the two reasonable restrictions which has been put upon your freedom of assembly without arm, peaceful assembly. Now you see freedom to form association or union, and there another new term which has been added by 97th Amendment Act 2011. However, the recent development is that 97th Amendment Act has been declared unconstitutional by the Supreme Court this year. Right. So what we have is right to form an association or union. Again, there are certain reasonable restrictions which has been put, and these are under Article 19, subclause 4. So it says we have the fundamental right to form associations or union, but this can be restricted on the grounds of sovereignty or integrity of India, public order, or morality. So these are the three reasonable restrictions which are put upon our fundamental right of forming associations or unions. Next are our right to freely move throughout the territory of India and settle down and reside in any part of the territory of India. So the freedom of movement and freedom of residence and settlement, these are the rights given under Article 19D and E. And there are reasonable restrictions put upon both of these rights under Article 19.5. They say interest of the general public and protection of the interest of the scheduled tribes. So these are the two reasonable restrictions which have been put upon Article 19.1D and E. Article 19.1F was relating to fundamental right of right to property. It has now been struck down from the list of fundamental right and moved to Article 300A, been made a legal right. Okay. So what happens here is we have Article 19.1G, that is right to practice any profession, carry on any trade or occupation. So this is again a fundamental right to see. Now this is quite understood thing that everyone will have their right to practice the profession or carry on any occupation and trade. But why in the Constitution of India it has to be explicitly mentioned? Just because of the social traditions, wherein a particular caste was not allowed to follow the tradition or profession outside their traditional domain. For example, the person who is cutting the hairs, their children will be cutting the hairs only. So these kinds of tradition compel the makers of the Constitution to make it a fundamental right that everyone has a right to profession. Now you see, this is different from right to work. Right to work is still a DPSP, but it's a right to choose the profession or choose the any trade you want to do. You can do. There is no limitation. You want to be a doctor, you can be a doctor. Forget about your previous background. If you have the merit, you qualify the particular qualification, you can go for that. Okay. So this is again a fundamental right. Of course, this is again restricted. So there is certain restriction. The first is state can prescribe the technical qualification in the interest of the general public. The reasonable restriction can be put by the state, and they can prescribe the technical qualification for practicing particular profession or trade. Or secondly, state can reserve certain offices or certain trade. For example, if the state wants, they can reserve trades like say atomic energy, railways. State can reserve that, okay, this is the occupation or trade or business. It will be partially reserved for state or it will be completely reserved for the state. So state is empowered that they can exclude the other persons from carrying out a particular trade, right? So these are the basic fundamental rights of freedom which are available to us. In the category of right to freedom, moving on, what we have is protection in the respect of conviction of certain offenses. Now why it is being put in the along the category of freedom? Because see, freedom is related to liberty. There is something difference between liberty and freedom. So freedom is kind of the absolute liberty without any constraint, right? So if your liberty is constrained, again it is compromising your freedom. So this is why you will find that all the rights which is with regards to the freedom and liberty are put together. They might include freedom, protection from conviction in certain cases, protection from arrest and detention, and the rights which are available during arrest and detention, So let's see them as well. That Article 20 protects us from certain conviction. First is ex post facto laws, that any person cannot be convicted for anything which he has done in past, and for that there was no law which at that point of time declared it to be an offense. This means no retrospective operation of the criminal laws can be there. If a person has done certain thing today, and if there is no law which declares that thing, particular thing as an offense, he cannot be punished tomorrow. So this is no ex post facto legislation. This is provided under Article 20 subclause 1. Article 20 subclause 2 says no person shall be prosecuted and punished for the same offense more than once. It says no double jeopardy to anyone. If a person has done one offense and he has been given a sentence once, appeal can be filed. That is a different story altogether. But the person cannot be convicted for the same offense more than once. Right? Third is no person accused of any offense shall be compelled to be a witness against themselves. That is what? Right against self incrimination. No person can be compelled to be giving a witness or evidence against themselves. So these are protection which is given to us under Article 20. This is protection in respect of certain conviction. Now is Article 21. This is the most important fundamental right, the most expanded fundamental right you will see, right to life and personal liberty. This mere two line fundamental right is the source of various categories of fundamental right. For example, right to privacy, right to fair and free trial, speedy trial. Then we have right to healthy environment. All of these are part and parcel of Article 21 itself, right? So before going to examination, I would suggest that you need to browse through the list, that what are the rights which are associated with Article 21, which are inscribed under Article 21. Specifically, one or two being very important: right to environment, right to privacy. These are the most important fundamental rights which are under the part and parcel of Article 21. So, Article 21 says no person shall be deprived of right to uh, deprived of his life or personal liberty except according to the procedure established by law. This means what? Any person, this firstly, it's not only applicable to the citizens, it's applicable to both citizens as well as non-citizens. Secondly, it says no person shall be deprived of their life or personal liberty except as per procedure established by the law. Here there are two concepts. One is the procedure established by law, which you find here mentioned, and another is the due process of law concept. One is procedure established by law, and another is due process of law. So procedure established by law is mentioned here, but there is a limitation in this concept of procedure established by law. It says that okay, every person shall have the right to life and personal liberty except as per procedure established by law. So it means that if a procedure established by law provides, their personal liberty can be curtailed. But the bigger question is, what if law is itself unreasonable, unfair? Then what happens? So herein there was a very famous case of Menka Gandhi versus Union of India. While interpreting this article and in this term, procedure established by the law, the judges, Supreme Court has opined that actually this they meant the makers of the constitution though have written the procedure established by law, but they actually means to include the greater concept of due process of law. What is the difference between procedure established by law and due process of law? Is wherever the concept of due process of law is being followed, the judges are also authorized to check whether the law are reasonable or not, whether the law is fair and just or not. So if judges finds that law is fair, reasonable and just, then only they can move ahead and curtail someone's personal liberty or life. If they finds that the law is unreasonable, they are not bound to follow the procedure established by that particular law, right? So what we follow after Menka Gandhi case is the concept of a due process of law. So in a nutshell, if the law is fair, reasonable and just, that will be binding. If the law is not fair nor reasonable, it is not binding. The judges are free to interpret and check into the fairness and reasonability of the law. Now, moving ahead, there is Article 21 capital A. This was inserted by an amendment to the Constitution, And this Article 21A provides for the right to education. Right to education was earlier a DPSP. This DPSPs was given under Article 45, and it provided that state shall endeavor to provide all the children between 6 to 14 years of age a right to free and compulsory education. But you see herein that now after 86th Constitutional Amendment Act, 86th Constitutional Amendment Act, what happened? That it was made a fundamental right, and it says state shall provide. So it is what the duty of the state, and it is the right of all the persons. Who, which kind of the persons? All the children who are among age group of 6 to 14 years. So those children who are among the age group of 6 to 14 years, they have this right to attain free and compulsory education, of course as per the law which state may determine. So in order to give effect to this law, the government, the parliament has enacted right to information act. The parliament has enacted right to information act, and this is in effect from 1st of April. This is in effect from 1st of April 2010. So right to education is providing for the procedure, the whole gamut under which right to education under Article 21A is getting implemented. So for Article 21A, you should note one important thing: the amendment through which it was inserted. It was 86th Amendment Act, and the year is 2002. The year is 2002. 86th Amendment Act, right? Now, moving ahead, Article 22 prescribes for certain rights if a person is getting arrested or detained in custody. So it says that any person who is getting arrested shall have basically three kinds of rights. Firstly, right to be informed of those grounds upon which they are getting arrested. Secondly, right to consult a legal practitioner of their choice. And third and most important is the right to be produced before nearest magistrate within 24 hours of such an arrest. So within 24 hours of the arrest which is getting made, the citizens, any persons who are getting arrested, have the right to be produced before the nearest magistrate, and this 24 hours shall be counted excluding the time of journey which is necessary from the arrest to the court of magistrate, right? So these are the three rights which are available to any persons who are detained or arrested. But this right will not be available to those two category of the persons who are mentioned here. So everyone who is getting arrested shall have three basic rights: to be informed, to consult, and to be produced before 24 hours. But these two persons, one who is an enemy alien and another, the person who is getting arrested under the preventive detention law. Any person who is getting arrested under the preventive detention law shall not have these kinds of rights to getting informed, to be produced before 24 hours. So for what are the situations there? What is the maximum limit they can be detained without getting informed or produced before the magistrate? Is this 3 months. So if a person who is arrested within the ambit of the preventive detention law, they can be kept into the detention for a period of 6 months maximum. Now, if this 6 months needed to be extended, that can also be done. But for that, an advisory board is to be constituted, which shall have the members who are qualified to become the judges of the High Court or has been the judge of the High Court. They will recommend that the preventive detention can be extended beyond a period of 3 months. So then it can also be extended, right? So these were the right to freedom which were given to us under Article 19 to 22. There comes next category of the fundamental right, that is right against exploitation. So in this category, there are two fundamental rights. One is Article 23. It provides for prohibition in human trafficking and forced labor. So traffic in human beings, and begar is like a term which is being used for unpaid labor. For example, anyone who is forced to do the labor and for that he is not paid. So begar and other similar forms of forced labor and the trafficking which is caused for these kinds of forced labor shall be an offense and which shall be made a punishable, right? So this is under Article 23. Article 24 forbids that no child below the age of 14 years shall be employed to work in any factory or engaged into hazardous employment. So this is Article 24 is forbidding child labor, and Article 23 is prohibiting the trafficking in human for forced labor. Right. So, but the bigger law here is the Child and Juvenile Labor uh, Prevention Act. This act was later amended into 2016. So it classifies every person into three categories. The persons below 14 years, they are not allowed to work in any place other than their family business or household work, same own household work. Persons from 14 years till 18 years, they are allowed to work, but they are allowed to work only in the non hazardous employment. And persons above 18 years of age, they are allowed to work in all kind of activities, right? So that is the part of that particular act. In Article 24, Constitution says no children below the age of 14 years shall be employed to working in any factory or mine or engaged into any hazardous activities, right? So this is right against exploitation. What we have is right to freedom of religion. It is there from Article 25 and it go on to Article 28. In a freedom of religion, you have to necessarily remember two things. One is what kind of freedom we have, and second is what kind of restriction is there on the freedom. So what kind of freedom we have? We have the right of conscience, right to freely practice, propagate the religion of our choice. But this religion, this right does not comes absolutely. This is again subject to public order, morality, and health, and other provisions of this part, other fundamental right. So what reasonable restrictions you have on your freedom of religion is public order, morality, health, and other fundamental rights. So subject to these restrictions, what every uh, person has got, right, is right to freely profess, practice, propagate religion of their own choice, right? Then we have freedom to manage religious affairs. So every religious denomination, now this uh, temple is being constructed and being opened. So these kinds of denominations are usually formed under the trust or waqf or any religious denominations. So Article 25 gives us the individual right. Every individuals of the country have the being the member of any religion, have their right to self faith, self conscience, practice any religion. But Article 26 gives the right to religion as a nutshell. So this is the collective right. It says subject to public order, morality, and health, every religious denomination. So this is talking about Article 26 is talking about denomination. Article 25 was talking about every individual, right? So that was an individual right. This is 26. 26 is a collective right. It says subject to public order, morality, health, every religious denomination or any section of that religious denomination shall have certain right, that is right to establish and maintain the religious institutions for charitable purposes, to manage its own affairs, to acquire the movable and immovable property, and to administer those property in accordance with the law, right? So even the individuals have got the right to religion, and the religion itself collectively has got certain right to hold and acquire property, to manage their own affairs, etc. Right? Now we have two other sets of right within the right to freedom of religion. One is freedom to pay taxes, and another is against the mandatory instructions, religious instructions in those institutions which are wholly maintained out of state funds. So it says Article 28 says no religious instruction shall be provided in any educational institutions which are wholly maintained out of the state fund. Mandatory religious instructions it is talking about. If any educational institution is there and they are being maintained out of the fund of the state, so there cannot be any mandatory religious instructions which has been given to the students within that educational institution, right? Then we move on to Article 29 and 30. These two are again the smaller rights provided for cultural and educational rights. Article 29 says any section of the citizens residing in the territory of India. You see, it is, I have already told you, 29 and 30 is a fundamental right which is only available to the citizens. So here we see any section of the citizen residing in the territory of India, which are having the distinct language, script, or culture of their own, shall have the right to conserve the same. Shall have the right to conserve the same. They have the right, and for that conservation, they can create any educational institution, and the state is also under duty that if there is any educational institution, so they will not discriminate on the basis of race, religion, caste, or color. So Article 29 is given to any section of the citizen, be it minority or majorities, right? But this is for the conservation of the culture or the language. But Article 30 is giving the right for the minorities. You see, all minorities, whether based on the language or religion. So Constitution of India recognizes both constitutional and linguistic minorities. Both. It's not about the religious and linguistic minorities. It is not only that only religious minorities is being talked about. So it is giving all minority, whether based on the religion or language, they have the right to establish and administer the educational institutions of their choice. And the normal rules of reservations, which is there under Article 15 and 16. If you go back and read Article 15, in that Article 15, subclause 4, you will find that the exception has been created for minority educational institution. It says these rules of reservations will not apply to those institutions which are established under Article 30. Right? So these are the five category of fundamental right. And the next category of fundamental right is itself given under Article 32, which is a kind of the right for the enforcement of the right. This is remedies for the enforcement of right. So this is the right to move to the Supreme Court. Any person whose fundamental rights is getting violated, they have the right, they can move to the Supreme Court for the enforcement, and the Supreme Court shall have the power. They have the power to issue directions, orders, writs, anything to restore the fundamental rights. And the Constitution recognizes five kinds of writs: habeas corpus, mandamus, prohibition, quo warranto, or certiorari. So habeas corpus is basically the writ which is given in the case of illegal detention to have the body of, you can say. So in case of any illegal detention, any arrest of the person beyond the legal permissible limit, any friend of that particular person can approach to the Supreme Court or High Court, and then if satisfied, court can grant this writ and ask the body of the person to be recovered and produced before the court. Mandamus is basically given, it's an order, it's a command. So mandamus is given against executive if they are failed in their legal duty and that has caused damage to someone's fundamental right. So court can issue certain direction of mandamus against those persons. Prohibition and certiorari are used against by the superior court to the inferior courts in case of violation of their jurisdiction, erroneous exercise of their jurisdiction. And quo warranto is the writ which is ordered if any person who is not eligible to hold any public office and they are holding the public office, so they will be asked what is your authority that you are holding this public office. So if they are failed to substantiate that okay they have this legal claim over the office, quo warranto can be issued against them and they would be asked to relinquish the office. So these are the five category of the writs. Now the bigger question can come, that is there any other court apart from the Supreme Court which are empowered to issue the writs? So yes, High Court are also empowered to issue the writs, but that power is given under Article 226. But there is a slight difference. High Court can issue the writs for the violation of fundamental rights, as well as High Court can issue the writs for the violation of fundamental rights as well as the legal right. High Court can issue the writs for the violation of fundamental rights as well as legal rights. Right? But Supreme Court can issue the writs. You can directly go to the Supreme Court in the case of violation of fundamental right only. So in the case of this thing, writ jurisdiction, the subject matter jurisdiction of the High Court is sort of larger as compared to that of the Supreme Court, because High Court can issue the writs for the violation of legal right as well as fundamental right for any other right, not only legal right. So in case of violation of any other right, you can approach to the High Court directly. You cannot go to the Supreme Court. But yes, if your violation of fundamental right is happening, then you can directly go to the Supreme Court, and this is your fundamental right itself, right? Now, the bigger question comes that can the fundamental rights be suspended or not? Is there any situation where the fundamental rights can be suspended? So this can be suspended by the virtue of Article 358, by the virtue of Article 358 and 359. These are the two articles which provides for the time and situations when fundamental rights can be suspended. And this is the case of national emergency. This is the case of national emergency. During the case of national emergency, the fundamental rights can be suspended, and the enforcement of those fundamental rights under Article 32 can also be suspended. Article 358 says if the national emergency has been imposed on the grounds of war or external aggression, Article 19 gets automatically suspended. So, fundamental rights of freedom, six kinds of freedom, which are available to us under Article 19, gets automatically suspended in the case of emergency is being imposed on the grounds of this thing, war or external aggression. If the national emergency is imposed on other grounds, so there are two grounds of imposing the national emergency. One is external aggression or war, and another is armed rebellion. So if the national emergency is imposed on any other grounds, all other fundamental rights, except with those rights which are given under Article 20 and 21, so except those which are given under Article 20 and 21, they cannot be suspended. Apart from that, other fundamental rights can also be suspended. So these are provided in these two articles, 358 and 359, that during the operation of the national emergency, fundamental rights can be suspended, right, provided on certain occasions as per Article 358 and 359, right? Now this thing, can the fundamental rights be amended? Yes, fundamental rights can be amended provided the basic structure is not changed. What about the rights which are available to the members of the armed forces? So parliament is empowered to curtail the rights of the members of the armed forces given under Article 33, and for this they had got certain limitation. They do not enjoy as much as fundamental right as we as an ordinary citizens enjoy, simply with the motive to maintain order and discipline in the armed forces. So all the members of the armed forces, Navy, Air Force, Army, and those forces which are charged with the maintenance of public order, it includes CAPF, paramilitary, and CBI kind of the organization, intelligence agency, counter intelligence agencies. So their fundamental rights can be restricted, and they can be restricted by the law of the parliament. So you'll find that Parliament has enacted the various laws providing for their functioning. Army Act, Navy Act, all of these acts restricts to a certain quantum the fundamental rights of the members of the armed forces. Right. So this was the chapter on the fundamental rights. Let's quickly scan through this part 4 of the directive principles of the state policy. Herein, these things you need to remember in literature, that what are the fundamental rights, in which article they have been given. In this specifically, if I'll be talking about the important ones. For example, this Article 39 is important one. You should be noting that what are the six principles it's talk about. So it talks about promoting a social order in the society, to prevent the concentration of the wealth, adequate means of the livelihood to the men and women, to prevent the concentration of the wealth, right, to prevent the concentration of the wealth under Article 39C, community ownership of the material resources, equal pay for equal work under Article 39D, it is talking about, to preservation of health and strength of workers. This is also an important thing which is given under Article 39E. And children's opportunity given to the children's in to develop in a healthy manner. So this is there in Article 39 of the Constitution. This is a DPSP. The major thing about DPSP is that you will find here in Article 38, it says, sorry, in Article 37, it says that the provisions are non-enforceable by any court. So non-enforceable means that in case of violation, if the case in case of non-fulfillment, you cannot go to court and demand their enforcement. Unlike the fundamental right, if fundamental rights are not fulfilled, you can go to the court and you can demand their enforcement. But if DPSPs are not fulfilled, because it depends upon the socio-economic capacity of the state, right, that whether they are able to implement them or not. If they want, they can enact and they can implement this fundamental right, they can give effect. Most of these DPSPs has been given effect, we will talk about it, right? But if even if none of one of the DPSPs are not getting implemented, none of the persons has claimed, they cannot go to court and implement, ask for the implementation of the of this DPSP, right? So let's move on. We have seen Article 39. They provides for six of the most important socialistic measures. Then we have Article 39A. 39A talks about the free legal aid. This concept of equal opportunity for the promotion of justice on the basis of equal opportunity. So this was later inserted by 42nd Amendment Act 1976. This was inserted again by 42nd Amendment Act 1976, Article 39A, right? Then organization of village panchayat, it is there under Article 40. Now this was still here till a 1973rd Amendment Act. 73rd Amendment Act, this was a non-enforceable part. But now Panchayati Raj, after the enactment of 73rd Amendment Act, has been made into the enforceable part of the Constitution. So you will find that we have whole gamut of 11th schedule, which is prescribing for the powers and functions from Article 243, so on. We have the process and the powers and the constitution of the Panchayati Raj. So earlier till 1993, it was also non-enforceable since it was the part of the DPSP, but now it is made into enforceable part. We have under Article 41 right to work, under Article 42 just and human condition of work and maternity benefit. This is under Article 42. Article 43 talks about living wages. Article 43 talks about the promotion of participation of workers in the industry. Again, it is done by 42nd Amendment Act. So you should keep an eye in on those DPSP which has been inserted by 42nd Amendment. Those DPSP which has been inserted by any other amendment or has been changed by any other amendment. And there are certain DPSP which is similar to the fundamental duty. So they might give you in the option that, okay, they are giving you four options and which of these are the fundamental duty or which of these are the DPSP. So DPSP and fundamental duty, you will have to read in sync with one another, right? I'll show you that which of the DPSP are confusing with fundamental duty, right? 44 is talking about 44 is talking about the uniform civil code. You should bare minimum know that under which article uniform civil code is given, because uniform civil code is talk of the town very recently. Article 45, as we were discussing article right to education, we have discussed that earlier. It was kind of the DPSP. So that is now moved to Article 21A. That 6 to 14 years is now made a fundamental right. But now words of Article 45 was changed by 86th Amendment Act again. And this provides that until the age of 6 years, from 0 to 6 years, the early childhood and care. This is the thing which is there providing under Article 45. 46, promotion of educational and economic interest of the scheduled caste, scheduled tribes, and weaker section. 47, duty of the state to raise the level of nutrition and improve the public health. 48 is organization of agriculture and animal husbandry. This is one DPS which talks about the ban on the slaughter of cows. So it's not only talks about the ban on the slaughter of the cows, but calves and other milch or draught cattle. But yes, of course, the cow has been mentioned here under Article 48. Then we have Article 48A, protection and improvement of the environment and safeguarding the forest and wildlife. So this is again inserted by the 42nd Amendment Act. This is again inserted by the 42nd Amendment Act. And this is one you will confuse with the fundamental duty. Read the words here carefully. States shall endeavor to protect and improve the environment and to safeguard forest and wildlife of the country. You go to Article 51A and you will find that there is a similar fundamental duty to protect and improve the natural environment, including forest, lakes, wildlife, rivers, right? And to have the compassion for the living creature. So might be they are putting this half in the statement, so you'll get confused. So you should note here that in the fundamental duty wala thing, it is including forest, lakes, rivers, wildlife, natural environment, all those things. But here under Article 48 capital A, it is talking about forest and wildlife of the country only. Right. So this distinction you should note between DPSP and fundamental duty. Again, a similar and confusing article is Article 49. So Article 49 says it shall be the obligation of the state to protect every monument or places of artistic or historical interest which has been declared by Parliament of national importance. And similarly, we'll find a confusing this thing, fundamental duty. So it says to value and preserve the rich heritage of our composite culture. So you should be able to see is to preservation of heritage and culture is the duty of the citizens, and protection of the monuments of the national importance, it is the duty of the state, which is a DPSP. So by this way, you need to have this distinction between fundamental duty and the DPSP. Then we have another thing, that is 50, Article 50, that talks about separation of judiciary from the executive. This is yet again the DPSP. So it is here the separation of judiciary from the executive. This is one of the DPSP. Now, judicial separation of powers is the part of the basic structure as well. And on this ground itself, the 99th Constitutional Amendment Act, which tried to insert DPSP, was struck down, being unconstitutional in the fourth judge case, right? So this is a very important DPSP, and of course, the separation of powers has been held to be the part of the basic structure of the Constitution. Rather, independence of judiciary has been held to be the part of the basic structure. And this article advocates for the independence of judiciary by providing that judiciary is independent from the clutches or the control of the executive. Now, we have Article 51. It provides for promotion of international peace and security. There shall be the endeavor of the government, the state, to promote international peace and security, maintain just and honorable relationship between the nations, respect for the international laws and treaty, encourage settlement of international dispute by arbitration. So from Article 36 to Article 51 these are what DPSP, these are DPSP, and they have been mentioned under Part 4 of the Constitution. Now, later on, with the 42nd Amendment Act, another Part 4A, was inserted into Constitution, and this provides this comprise of single article, that is Article 51A, and it prescribes for fundamental duties. So, in original, this fundamental duty chapter was inserted in 42nd Amendment Act 1976 based on the recommendation of a committee which was headed by Swaran Singh. So Swaran Singh committee gave certain recommendations, and out of those recommendations, 10 things, 10 points were included as the fundamental duty. So these are to abide by the Constitution, cherish and follow noble ideas of our freedom struggle, to uphold and protect the sovereignty and integrity, to defend our country and render the national services whenever called to do so, to promote the spirit of harmony and common brotherhood, and to renounce the practices which are derogatory to the dignity of the women. This is also an important fundamental duty. Just now we have seen protection of natural environment, forest and lakes, to develop the scientific temper, to safeguard public property and observe violence, to strive towards excellence in all spheres of individual and collective activity. So these were the original 10. Now, later on, with the 86th Amendment, 11th fundamental duty was also added. It says, whosoever is a parent or a guardian, it is their duty to provide opportunity for education to their child or what between 6 to 14 years. So now you are saying that 86th Amendment Act is one of such amendment which has made changes in the fundamental right, because it inserted Article 21A. It also made changes in DPSP because it made changes in Article 45, and it also made certain changes in this thing, fundamental duty, by inserting the 11th fundamental duty, right? So this is the basic overhaul, right? From Article 1 to 51A. Till here, you should be noting that you are remembering from article by article. They might ask the article directly, they might ask the content of it, right? So this was the gist. Now we shall be starting with this next segment that will be consisting of our parliament, legislature, judiciary, our executive, right? So just we'll wait for 5 minutes for a break. Chalo. So let's resume. Herein, we'll try to give a quick glimpse of the legislature, in a nutshell, about the few questions which might come from parliament portions, and the areas like you see the judiciary, the this thing executive. Let's quickly do that, and I'll try to touch those areas which are the most important areas according to examination point of view. So in parliament there are certain bills that we will be talking about. Those bills you might have neglected in your ordinary preparations. So I'll just give a glimpse of what are the different kinds of bills, what are the process there of the parliamentary processes, and then we will talk about the executive, the basic details, right? And let's see how far we are going, right? So you see, I'll be just giving certain things. Parliament, the legislature. So herein, the major purpose of the legislature is to enact the laws, right? What During the making of the laws, there will be whole lot of procedures which will be required. So parliament will do certain things, will take certain actions based upon their own process. So firstly, we should be noting that India has got a bicameral parliament. India has got a bicameral parliament. Bicameral means which is having two houses. So India's parliament consists of two houses. One is Lok Sabha, one is Lok Sabha, and another is Rajya Sabha. Another is Rajya Sabha. So Council of States, that is called in English, and this is called House of People. This is called House of People, right? So Lok Sabha is House of People, Rajya Sabha is Council of State, and the third element of Indian Parliament is the President. So Article 1779 says, President of India, the Parliament of India shall comprise of, I'll show you, under Article 79 it says that Parliament of India shall comprise of, shall consist of President and the two houses which is known as Council of State and House of People, right? How Council of State is constituted? So Council of State has total of a maximum of 245 members now. Out of that, 12 members are nominated by the president, and rest 200 20 233 233 members are elected from states and union territory. This is the present. 245 is the present, right? What is the maximum is 250. So out of this 250, 12 will be nominated and 238 will be elected from the states and union territory. As of now, what we have is 245. Out of that, 12 are nominated and 233 are elected from various states and union territory. So which state has got how many seats in the council of state? It is given again in the fourth schedule, right? So fourth schedule talks about the allocation of seats in the union council of state to the different state, highest being given to Uttar Pradesh, that is 31, and thereafter their least is to one seats to various states, northeast Goa, etc., right? Now, how these elections are conducted? So, elections are to the Council of States are conducted on the basis of proportional representation through single transferable vote. Proportional representation system through single transferable vote, where there is no one person, one vote kind of the same thing. There is a value given to one person's vote, and every person who is going to vote will give one preference that okay, he is my preference number one, he is my preference number two, he is my preference number three. So that is called preferential system of voting. You should be noting the system is called proportional representation, proportional representation, proportional representation through single transferable vote, PRSTV, proportional representation through single transferable vote, right? The remaining 12 members who are nominated by the president, and they are nominated from this field: literature, science, art, and social service. What about the composition of the House of People? So how House of People is constituted? So total, as of now, there are 543 members, and whole India is divided into 543 constituency, and these 543 members of the House of People are they are elected directly by the people. We as citizens go and vote into these elections. So these are the persons who are directly elected by the people. Herein, I go and vote, that has a one value. You go and vote, you have a one value. So one person, one value. So it's called first past the post system. What it is called? First past the post system. If first past the post system. So every person has got a value of vote, and this system is the election is conducted on the basis of universal adult suffrage, that any person who is above 18 years of age are entitled to vote. So for one constituency there will be one winner, and all the person in that constituency will be voting for that, right? As per now, maximum strength is 543. This is not always fixed 543. So the Constitution of India prescribes that after every census, there has to be readjustment. So census is conducted after 10 years. After 10 years, there will be a process that will be called delimitation. The process is called delimitation. So this has to be conducted after every census. This delimitation has to be conducted after every census. But as of now, due to population imbalance, this delimitation has been paused till the year 2026. So when it was paused, it was first paused by the 42nd Amendment Act. This delimitation was paused. Thereafter, the year was taken to be 2001. In 42nd Amendment, they told that till 2001 there will be no fresh delimitation. But later on, it was 84th Amendment Act 2001, which increased this pause on the delimitation till 2026. So till 2026, the seats cannot be more than 543. After 2026, the first census will be taken, and in that census, based on that census, there will be fresh delimitation, and the seats to the Lok Sabha can be increased, right? So this is how the Lok Sabha is constituted. What is the qualification of a person that he can become the members of the Lok Sabha or Rajya Sabha? So basic qualification is that person should be a citizen of India, And if they are trying to become the member of the Rajya Sabha, they need to be at least 30 years of the age, 30 years for Council of State, that is Rajya Sabha, and 25 years for the Lok Sabha, if they are a citizen of India or if they are of this particular age, and they possess other qualifications as prescribed by the Parliament. For this purpose, Parliament has enacted a Representation of People Act, Representation of People Act 1951, and in that particular act, it prescribes for various qualifications for any persons who can become the members of the Parliament, right? Now, we have seen that how parliament is constituted. Then there are sessions of the parliament. So whole year is divided into three sessions. One is budget session. Budget session will start from the 1st of Feb. So this is budget session. Now the second will be the monsoon session. The third will be the winter session. Right. So there are three sessions, and this gap between these two sessions are called recess. The power to call a session to summon, that is called summon the sessions of parliament, is lying with president. President has the power to summon the sessions of Lok Sabha, Rajya Sabha. President has the power to prorogue. So that is the end of the session, and parliament will go on the break, and then it will meet for the next. So that is called prorogation. And thereafter dissolve the House of People. Now, why it is House of People only getting dissolved? Because the Council of State is a permanent house. Council of State, that is Rajya Sabha, can never be dissolved. That is a permanent house, right? Because you see, the tenure of member of the Lok Sabha is 5 years. Once a person is elected to the Lok Sabha, they have got a tenure of 5 years. But thereafter, in the Rajya Sabha, once a person is elected, they get the tenure of 6 years. But not after 6 years, all the person is going to retire. It's that after every 2 years, one third of the persons will retire and one third will be elected fresh. So the Rajya Sabha continues to be a permanent house that is never dissolved. So president has the power to summon the sessions of both the houses. President has the power to prorogue the sessions of the both the houses, and president has the power to dissolve both the houses. Now it says that a maximum gap between two sessions of the parliament cannot be more than 6 months. So maximum gap between two sessions of the parliament will be maximum of 6 months. Within 6 months, there has to be the sessions of parliament, right? Then there is a power of the president that before the commencement of first session of every year. So I have told you that there are three sessions in every year. First is budget. So before the commencement of the budget session every year, and before the commencement of the first sitting of the Lok Sabha after the general election, 2024 में भी चुनाव होगा. The fresh Lok Sabha will be constituted, and before it meets for the first time, the president will make an address. So president makes an address when? To the both the houses assembled together. When he can make the address? First session, before the first session every year, and after the fresh election has been constituted. So before the first sitting of the Lok Sabha, president makes the address to the both the houses of the parliament, right? Thereafter, there are all the members who are there. They have the right to attend, but apart from them, attorney general and ministers, minister may be from the Lok Sabha, minister may be from the Rajya Sabha, but both ministers and attorney general have the right to attend in both the houses. Suppose that Mr. Prime Minister Modi, he is the member of the Lok Sabha, but he want to discuss something in the Rajya Sabha, he can go. He has the right because he is the minister. Similarly, all the minister have the right to participate in the proceedings of both the houses, but they can vote only where they are the member of. Suppose the Modi is the member of Lok Sabha, so he can vote only in the Lok Sabha, but he can participate in both the houses. Attorney General is not a member of either houses, but he has got a special power to participate, so he has no power to vote. He can simply participate and discuss in both the houses, right? In order to conduct the meetings of both the houses, we have the chairman and the deputy chairman in the Council of the State. So Vice President of India is the deputy chairman, ex officio chairman of the Rajya Sabha, and then we have deputy chairman to assist him. Similarly, in order to conduct the meetings of the Lok Sabha, we have is what? Speaker of the Lok Sabha. So after the Lok Sabha has been constituted, the 543 members will sit together and elect one speaker. So speaker is one of the persons who is from the house itself. Speaker is from the house itself. Speaker is from the house itself. But here vice president is an outsider. He is not the member of the Rajya Sabha. Okay. So what are their powers and duties? These are the speaker and the chairman of the Council of State. These two are the persons who are empowered to maintain the discipline, to conduct the sittings of the house, both the houses, and if required, they can suspend certain members, they can disqualify certain members on the basis of anti-defection. So anti-defection is given under 10th schedule. Anti-defection means that any person who after winning the election has changed from one political party to the other political party, right? So this is about the speaker and their power, the chairman and their powers, right? Now coming to the procedure which is happening in this parliament. So we'll go to few technical terms which are there in article 108 and 1010. 108 is providing for special sessions of the parliament, that is joint sitting. So ideally Lok Sabha will sit separately, Rajya Sabha will sit separately, but there are occasions when both the houses will sit together, that is called joint sitting. So when it is possible, first if the president is addressing that, we just now we have seen the president addresses the joint sitting, so then both the houses will assemble together. Otherwise, if there is a deadlock between the bills, if there is a deadlock between both the houses, so what do you mean by deadlock? Suppose that if a bill has been passed by one house and it is rejected by the other house, that is a deadlock. If one house has passed the bill, other house has amended the bill, but first house is not agreeing to that amendment, that is also a deadlock, right? Or if first house has passed the bill and goes to the second house and that house is not taking any action for a period of 6 months, so now joint sitting can be called. Now who has the power to call the joint sitting? It is the president of India who has the power to call the joint sitting of the parliament. So president of India can call the joint sitting. Members of Lok Sabha and Rajya Sabha will sit together and they will do the voting and then the bill will be passed. This is called joint sitting. The joint sitting is presided by the speaker of the joint sitting is presided by the speaker of the Lok Sabha, not the chairman of the Rajya Sabha. Right. So this is a technical term about the joint sitting. You'll find if you read the articles, you will find the same thing. Then we have another key term which is a money bill. Money bill is defined under Article 110 of the Constitution. What amounts to money bill? If any bill which is trying to serve these five purposes, actually six purpose, which is there in the F. So any of the six items which is mentioned under Article 110, for example, imposition of the taxes, borrowing of the money, giving the guarantee by the government of India, custody of the consolidated fund, appropriation of money out of the consolidated fund. If there is any bill which is seeking to do any of these changes, they will be called money bill. But only those things which are mentioned under Article 110. If a bill which is mentioning 1 and 2 from Article 110 and it contains certain other thing, that will not be called a money bill. So money bill means anything which is purely under the scope of Article 110. So what is the process which is being followed in the case of money bills? So firstly, money bills cannot be introduced in the Rajya Sabha. If a bill is a money bill, it will be introduced only in the Lok Sabha. And before the introduction of money bill, it requires the prior assent of the president. Prior recommendation, not the assent. Prior recommendation of the president is required to introduce any bill. The bill can be introduced only in Lok Sabha. Money bill can be introduced only in the Lok Sabha. Now, once it is passed in the Lok Sabha, it will go to the Rajya Sabha. Once it is passed in, the power to certify any bill, the power to write one thing as well, power to certify bill as money bill lies with the Speaker of the Lok Sabha. Lies with the Speaker of the Lok Sabha. After the bill is passed from the Lok Sabha, it will go on to the Rajya Sabha. Rajya Sabha do not have any power, rather, it can maximum keep the bill with 14 days, with itself for the 14 days. Within 14 days, Rajya Sabha will have to pass the money bill, otherwise, it will automatically be passed. Rajya Sabha has no power to amend the money bill or reject the money bill. Right? So once this bill is passed, money bill is passed by the Lok Sabha, it will go to the Rajya Sabha. Rajya Sabha has got no effective power. It has only one power. It can hold the bill till the 14 days. Right? Then we have one particular thing about the powers of the president, that once a bill is passed by both the houses, then what powers president has. So this power of the president has been given under Article 111, and this you can call it by the name veto powers of the president. So it says when a bill is presented to the president, president either shall declare the assent or he is withholding from that particular thing. So withholding the assent is called veto. So this is where he gets his veto power. So what happens that president has got certain option. Firstly, he can give the assent to the bill will become the law. Secondly, he can return the bill for the reconsideration of the parliament. But if parliament is reconsidering the bill and recommending again back to the president, here president is supposed to give the assent to the bill. He will be bound to give the assent to the bill. Right? Apart from that, president can directly, absolutely deny that I will not sign. That is called absolute veto. President can reject a bill as well. And apart from that, there is a very unique power. President can choose not to do anything on the bill. He can sit indefinitely on it. This is called absolute veto of the president. So if a bill which is being presented to the president, he has got these many powers. This is there in the Article 111. But you should note one thing, if the bill which is passed by both the houses of parliament is a constitutional amendment bill, then President has no power. President is bound to give an assent to the Constitutional Amendment Act. So President do not have any power in the case of Constitutional Amendment Act, right? The next important term which may be in use during the time of parliament is annual financial statement, and this is what is budget. Right? So it says president shall cause to be laid before each house an annual financial statement, that is what is budget. So it is the duty of the president that he will ask the government to cause to be laid before both the houses an estimate of receipts and expenditure, that is budget, that will be laid by both the houses of the parliament. uh, and this budget annual financial statement is essentially a money bill. So all the process of the money will be followed there itself. In the budget, the expenditures are put into two categories. One is expenditure which are charged on the consolidated fund of India, and their list are mentioned here: the salaries and allowances of the judges, the salaries and allowances of the president, the salaries and allowances of the CAG. All those things are put under salaries expenditure which are charged upon the consolidated fund of India. Now, what is the meaning of expenditure charged upon the consolidated fund of India? Is that Parliament cannot vote on these expenditures. Parliament cannot vote on these expenditures. If Parliament cannot vote, so this cannot be reduced. Those expenditures which are made from, so expenditure दो तरीके से हो सकते हैं. One is expenditure charged and another is expenditure made from the consolidated fund of India. So these expenditure are votable by the parliament. If parliament want, they can reduce that expenditure. But those expenditure which are put in the form of expenditure charged, they cannot be voted by the parliament. Budget is a kind of the money bill itself. There are certain key terms like vote on account, vote of credit. So this may be certain times, very rarely will find in judicial services examination, right? Apart from that, both the houses, Lok Sabha and Rajya Sabha, has got this ability. They have the power to frame the rules with regards to conduct of their business. So accordingly, Lok Sabha has also made the rules. Rajya Sabha has also made the rules. Right? Now, another important with regards to this is that legislative power of the president, and this is technically known as ordinance. So, lawmaking is technically the power which is given to the parliament, but in order to meet the extraordinary situations, the executive, which is the president, has been given certain power to promulgate the ordinance. It is saying that what if at any time, when the both house, except when both the houses of parliament are in session. So meaning when both the houses of parliament in session, when both are in session, president cannot promulgate the ordinance. Apart from it, he can promulgate. Even if one house is not in session, president can promulgate the ordinance. So if both the houses, except when both the houses of parliament are in session, otherwise at any time he can promulgate when he is satisfied that such a circumstance exists which renders it necessary to be addressed by the law. Because law making authority is not present, parliament is not present, so president can promulgate the ordinance. Now president can promulgate the ordinance, but that ordinance should be passed by both the houses of parliament within 6 weeks. Within 6 weeks. Within 6 weeks. Right? President can pass the ordinance, but that ordinance should get passed within 6 weeks. But what if during the time of promulgation of ordinance, one of the house is not in session, and that house comes into session after 4 months? So from when, which date this 6 weeks will be counted? From the assembly of both the houses together. So 6 weeks will be counted from the date when both the houses are meeting together. What could be the maximum gap between two sessions of one house? It's 6 months, right? And what is the time which is required to pass an ordinance? Is 6 weeks. So what is the maximum limit of an ordinance? Is 6 months plus 6 weeks, right? So these were certain legislative terminologies which I suppose that could be useful for your examination. Apart from it, before going into examination, I will suggest that you should be going for reading a bit about the judiciary, appointment of the judges, the jurisdictions of the court, powers of the president, governor, right? So governor is also having the same ordinance power what president has, but subject matter is different. President can promulgate on union list, governor can make on whatever legislative matters their legislature are empowered. The legislature wala portion you might have not have covered. So this is why I thought that let's bring out certain trivial points and discuss that. From article 1 to 51A, you should be it should be on your fingertips. It's very very important. Those are the founding philosophies of our constitution. The you should also note certain authorities which are there, for example attorney general, advocate general, CAG, etc. So you should be reading about those articles also. And one rather two chapter which becomes very important, that is center state relationship and this thing, emergency. So try to cover those things. We will still have certain time that you can revise. I'll be winding up this session as the clock is ticking. If you have any queries, you can put in. If not, then I shall take your leave. Thank you for turning up.